Good afternoon, everybody, and thank you for joining us to Not Your Mother's Cookies panel, Navigating Privacy Risk in the Age of Digital Tracking. My name is Sheila Spence, and this year I'm the Young Lawyers Division Chair and also the Privacy and Data Security Liaison, YLD Liaison to the section. So before we get started, with our questions to the panels, I just want to go over a couple of housekeeping rules. Please keep yourself on mute. We have a lot of you all and a few panelists. If you have a question, you can drop it in the chat and I'll monitor all the questions. And if we have time at the end, I will be sure to circle them around to our panelists. With that said, before we dive into the questions, I want to give my panelists the opportunity to introduce themselves and thank you for being here. So starting with Karen, I'll pass it on to you just for brief intros.
Hey, everyone. Thanks for joining. I'm Karen McGinnis. I am an attorney at Moore Van Allen. I'm located here in Charlotte. I chair our privacy and data security team here. I'm also this year's chair of the North Carolina Bar Association Privacy and Data Security section. Glad to be here.
Thank you, Karen. Will.
Hey everybody, my name is Will Quick. I'm a partner at the Brooks Pierce Law Firm, where among other things, I do privacy and data security law, also litigate other issues. I am a former chair of the Young Lawyers Division, so I've had Sheila's job, and I'm a former chair of the privacy and data security section, so I've had Karen's job right now as well. Happy to be joining you all today.
Thanks, Will. Dominique.
Hello, everyone. Hello, everyone. My name is Dominic Moore. I am a senior product counsel at HubSpot, a software company focused in B2B marketing. I previously I was a privacy counsel at Credit Karma, so that's my privacy experience as product counsel. I do the run of the mill product privacy contracts, commercial marketing, all the things. So happy to join you all today. Talk about cookies.
Sounds good. And before we just jump into the legal issues, let's take a step back and talk about what cookies actually are. So, Karen, starting with you, from a legal standpoint, how do you define cookies and tracking technologies?
Thanks, Sheila. I think of trackers as a really broad term that covers any technology that collects or transmits or stores data about a user's online user's behavior, their device, their identity, potentially without the user's explicit knowledge or consent, where the rub comes in. So trackers can include cookies, which is a small text file that it's downloaded to the user's browser and can collect data about their device, their IP address, geolocation, other information that the cookie's designed to collect, or a pixel, which when you think about pixels in an image on a computer, just there, a little clear pixel on the website, which does something similar, sends information back to a third party. Web beacon, session replay, scripts, browser fingerprinting, all kind of falls under these trackers. The law doesn't really define cookie per se or trackers per se. What the law is more about, how do cookies and pixels and trackers fit into existing laws? So, for example, is a cookie and a pixel a trap and trace device under the California Information Privacy Act? Well, I'm sure we'll be talking more about that as well. The important thing is, I think that cookies come in different flavors, to kind of use the pun there. So there's session cookies that go away after your website session is over. There's persistent cookies that stick around and continue to collect, so the next time you visit that website, will send that information back to the website so it can recognize you. There's strictly necessary cookies, so those cookies that have to be there and collect the information in order for you to use the website. So, for example, what items are being held in the shopping cart on a website. There's marketing cookies, there's statistical and analytical cookies, so a variety of different types. And there's first-party cookies, which are the cookies that the website you're visiting will drop. And then there's third-party cookies, which are cookies that the site allows some third party that you're not necessarily directly interacting with to drop on the site and collect information about, sends that information back to the third party, which is where we really see the legal claims come in. Those are the danger cookies, so to speak.
Thanks, Karen. I love the analogy that you had about the different flavors of the cookies. That's really helpful as a sticking point. So you started to talk about the laws, and Will, I just wanted to jump to you in case you had anything additional to provide us as far as background. Now that we know a little bit about what cookies and the tracking technologies are, what types of laws are being used by plaintiffs' lawyers?
Well, Karen alluded to some of this with the reference to SIPA, or the California Invasion of Privacy Act. But I'll sort of take one more step back and say, and sticking with the flavors, analogy, I think there's sort of two versions of the laws that we most commonly see these claims brought under related to tracking technologies. The first one would be generally old laws, and I say old, I mean, 20 to 40 years old and older in some cases, related to law enforcement, surveillance, or suspect tracking, wiretapping, pin register, trap and trace, and we'll go into some more detail on that in a minute, that are being repurposed for sort of digital and online, times we live in now. And then the other flavor is still generally old, but not always so. Laws related to privacy of certain persons or certain activities that might be undertaken by persons, also being repurposed. And I'll give examples kind of both of those in a second. The common theme, I think, in the types of laws we see, though, or the one common theme in all of them is that they have statutory damages in the couple hundred to multi-thousand-dollar range. Almost to a T, you can make sure that is the case, because that is what interests plaintiffs' lawyers. And going back to Karen's answer, how do you define the things? Well, it's probably the plaintiffs' lawyers who are defining them. And they are finding laws that they can use creative definitions of cookies to apply to get those statutory damages. So just to give kind of examples, and again, Karen already mentioned SIPA, but an example, that is one of those laws that is being repurposed. Generally speaking, these laws, where they are being used, are in states that have something called two-party consent to their historical surveillance laws. So North Carolina wouldn't be a great fit for this, because our state law is a one-party consent to taping a telephone conversation, for example. It's not exclusively one party. There are a few exceptions, because there are some places in the Federal Electronic Communications Privacy Act, which are one party, but then have some narrow exceptions for things like use of the tracking in relation to a crime or commission of another tort. I won't go too deep into that, but it's not always two party. It is more commonly that. And so a good two-party example is SIPA, the California Invasion of Privacy Act. And then under that, there's sort of two versions. There's kind of pure wiretapping, or digital eavesdropping is kind of how it's been, repurposed, based on capturing the contents of what you intended to communicate online to someone else, to the company you are, on a website for, or possibly content that is being shared with a third party. And that's sort of one version of the SIPA claims. The other version of SIPA and similar laws are the pin register and trap and trace claims. And those are not necessarily related to the contents of the communication, but are more analogous to the old, like, if you put a tracking device on somebody's car, and that tracking device was sending location information about where that person was driving around a city. Um, the creative plaintiffs lawyers are repurposing these pin register and trap and trace laws in that way. And so a pin register device, at least historically, recorded outgoing numbers from a particular line. A trap and trace device recorded incoming numbers, and can again give you, some information about where someone is calling from or coming from. Um, another very interesting, and I'll stop after this one, version of these laws, the ones I said, other privacy laws that sort of are intended to protect certain persons or certain activities of persons. An example of that is the Video Privacy Protection Act, which is a federal law. It was passed in 1988. It's a little bit of a funny story behind it, following a Supreme Court confirmation hearing of a gentleman named Robert Bork. He did not join the Supreme Court. There was never a Supreme Court Justice Bork. But during his confirmation hearings, a news reporter had gone out and gotten information about his and his family's video watching history and published that in the newspaper. There was nothing salacious about, Judge Bork's video viewing, but apparently members of Congress were worried about possibly their own video viewing and others getting a hold of it. And so they passed a law that prohibits videotape service providers from sharing information about the consumers who rented videos from like an old Blockbuster or something. And that's being repurposed with embedded video on a website, for example, and a session replay technology that might show what video someone clicked on or what video someone was interested in. And so now we're seeing claims under the VPPA because it has a $2,500 statutory damage. So that's kind of some examples of the laws that are being used.
Thanks, Will. That's really helpful. And I never heard that story before. It makes me miss Blockbusters. I think there's one still standing in one whole
Maybe.
country. Okay, so now that we know about what tracking technologies are, we have a really good understanding of the laws. Dominique, how would you say that you practically balance all of this, balance enabling business goals like personalization and analytics that your team may need, with like the risk appetite of the organization?
Yeah. So speaking directly from my HubSpot perspective, we treat privacy as a product constraint. And so we think about the business outcome and the privacy guardrails at the exact same time. We do a lot of like high level things first. So first setting like you said, a risk appetite, something, and thinking about it in like terms of tiers, low to high, low, something aggregated analytics that might just be a product a product person or engineer just kind of like looking and seeing how someone's using a prompt, but not necessarily using anything related to an individual, but more in the aggregate. Versus medium, so like cookie-backed personalization or something hashed or something high, so like session replay, keystrokes, anything like that. So once we know exactly what the product is doing, we can set the risk appetite and then we can create our guardrails around it. Something with HubSpot is because we're not a regulated industry, there are we do have a lot more freedom with our risk appetite versus like when I worked at Credit Karma. It was very cut and dry, financial institution, you can't do everything. But because we're in B2B marketing, we have a higher risk tolerance. And so that allows us to be innovative. And so in thinking through like the guardrails, the biggest thing that we're as a product counsel, as a product or privacy person that I'm concerned about is what first party identifiers do we have? Are we using pseudonymization or hashing? Are we aggregating the models? Do we have DPIAs in place? Are there any like backdoor sharing things going on? Are we using our own cookies or somebody else's cookies? These are all the questions I'm asking. And truthfully, most of the time, because HubSpot is very privacy forward, privacy focused, We train our engineers to already know the answers before we're coming to them. And it allows us to be more innovative. Um, so to wrap it all up and answer the question, know your risk appetite, have a tiered system for evaluating risk, and then train non-privacy, non-legal people on privacy guardrails ahead of time so they design the product with privacy in mind, and that allows us to have a greater risk appetite.
I'll jump in too, Sheila, if I can, just on
Yeah,
that.
please.
And it's I work with clients, and I'm sure Kieran as well, from a lot of different industries and backgrounds and familiarities with these kind of concepts. But one thing that I typically find is the case, particularly for smaller to mid-sized business clients who might outsource their web development or their or those sort of activities, is that they're just doing the norm, right? They think, or at least that's what they think they're doing. They're just doing what is normal by having these technologies on their websites. And a lot of my clients are B2B, and they don't really use this stuff. It's just there because somebody developed a website and there was a template for it. And so I think it's part of it's just understanding who your audience is and who's coming to your website. And so if you don't need it and you're not using it, maybe you just take it off for that reason. And the other thing I was going to mention, I think Dominique mentioned that the regulated industries, it made me think about, well, these laws have been around a while, and plaintiffs' lawyers have sort of creatively poked around the edges for, maybe 10 years or so, roughly. A lot of this really kicked off in sort of coming out of the pandemic. And there was this article in the markup about Facebook sort of getting information from hospitals and other healthcare organizations. And so one of the original, sets of these that I dealt with was for clients in the medical space. And that really, kicked off a lot of this with those regulated industries. So that was a good point, Dominique.
Yeah. And I know we'll get into auditing and what companies should do, but for anyone who's listening who is in-house or who represents a company, really important to know, and to Will's point about smaller businesses, especially who are just using a software development kit for their website, there can be pixels within that software development kit that you're not even aware of. And that could be sending and collecting information and sending it back to Amazon or Google or whoever, TikTok, whichever kit that you're using. So important with the influx of these claims and especially in California, to know what's on your website, what pixels, what cookies, what trackers, how are they being used, and who's the information getting sent to? Because again, that's where the rubber really hits the road, is where you have information of a consumer that's getting sent back to a third party that the consumer didn't know about or didn't consent to. So really, really important.
Excellent points. I like how each of you hit on risk and how you advise your clients based on the risk appetite of the companies, and also thinking about the regulated industries, right? So business to business, different from dealing with the financial institutions or the health institutions and the like. So speaking of advising clients, one of my next questions, perhaps starting with you, Karen, how are you advising clients on the interplay of, say, between GDPR consent or the CPRA opt-out requirements? Do you think that companies are over-complying or perhaps underestimating the differences between some of these laws? What have you seen? What have you been advising clients to do?
It's such a great question, and it's been such an interesting evolution to kind of go back. Where did cookies come from? Why do we even have cookie banners and consents? So it really started with the e-privacy directive in the European Union. It was a 2002 law. It was amended in 2009, went into effect in 2011. And the European Commission realized that, hey, there's these websites can drop this bit of code onto users' browsers, and they're collecting information that's personal information. And there needs to be some regulation regarding this. So the e-privacy directive that went into force was amended in 2011, required consent for collecting information through those cookies, but had a carve out for strictly necessary cookies. And when we're looking at if you've had, I'm sure everybody has had a cookie banner pop up, and if you've looked at a cookie policy, you have those options to say which ones cookies you want to consent to. And strictly necessary is like always on, is you have no choice. This is kind of this outgrowth of the European Union. When GDPR came into effect in 2018, Article 30 kind of piggybacked on that, again, recognizing that these websites were collecting personal information through these cookies and required consent. And so we really started seeing all these cookie banners start popping up in order to comply with GDPR. And GDPR requires, an explanation of the cookies and what it does. And so for clients who are operating in the EU, we're creating cookie policies, and we're doing audits and working with consent management platforms, obviously, to comply with GDPR and the e-privacy directive. In the early days of comprehensive privacy laws in the US, there wasn't this concept. So as Sheila pointed out, CCPA, California Consumer Privacy Act, was opt-out. So we didn't worry about cookie banners. And I'm sure Will's the same way. We're like, oh, no, you don't need to do a cookie banner in the US if you're not operating in the EU. You don't worry about it. As we saw more comprehensive privacy laws come online, some of our clients perhaps were collecting sensitive information, and where these laws may be required opt-in. So we started looking at more requirements with respect to cookie banners and opt-in requirements. The real kicker, at least for me, is when these SEPA claims really took off, as we'll explain, both the eavesdropping, wiretapping sort of claims, and then this proliferation of the trap and trace claims really starting last year, I think, when they really started taking off. And so those claims are, as Will said, for example, with trap and traces, you were taking information and sending it to the third party. And the best way to defend against those claims is to show that the individual consented. So a cookie banner that's very clear and says we're using cookies, it's collecting information, we share it, here's a link to our privacy policy, has become really important in the US. Even if you're not a consumer-facing business, we've all had clients who have received letters and demands who are B2B businesses, but you have an individual, just a natural person who's on a website who's claiming a violation of these laws because they're a California resident through the collection of it. So to answer your question, I'm looking at for clients who are certainly if they're in the EU and in the US, maybe we've got a lot of clients who their parent companies in the EU. We're following the lead of the client. If they say, hey, in the EU, we have a cookie policy, we have a cookie banner, this is our company philosophy, we're going to deploy it in the US, that's great. we'll follow that. Additional information isn't a bad thing as long as there's regular audits, making sure that the cookie banners are working consistently, that the opt-outs are working and the opt-ins are working properly. So that's really, really critical for any company. Otherwise, if I have a client who is subject to the jurisdiction of courts in California, we walk through that risk analysis. Think about whether you want to have a cookie banner that addresses the SEPA type issues and provides the required notices, particularly and maybe only if there are third-party cookies. So is information being sent back to some third party? You want to give that notice, and that cookie banner is a great way to do that consistently. If I have a client who's not subject to California jurisdiction, or if a client's not using third-party cookies, I'm less worried about a cookie banner. So it's not a one-size-fits-all. There's this risk analysis, absolutely, cost benefit, but cookie banners to me are not a bad thing, particularly with respect to any client that's going to be doing business in California.
Yeah, and I'll throw in, I think one of the really interesting things that we're going through right now is that, and Garen hit on this, is, GDPR, e-privacy directive, those were sort of, they had explicit intents to address the use of these tracking technologies and cookies, and that was behind those laws. It really wasn't, except for maybe, except for the sensitive information and maybe minors and a few other specific areas. It wasn't really part of the comprehensive consumer privacy laws in the U.S. It's this sort of roundabout way of using these other laws that we have ended up with cookie banners, so prolific in the U.S. And now the EU is in the middle of a reform process for their cookie banners, because they have realized that doing what they did has caused fatigue. If you talk to European friends and others, they will tell you that it is almost, it's just gotten to be too much, that you get these pop-ups all the time. So it's just interesting to me that we have ended up in the U.S. in a place that they are already trying, after a couple of years of this, to go away from in the EU.
Yeah. To Will's point, what he's talking about is, if anybody's heard about it, is a digital omnibus. There was a Draghi report folks may have heard of, where the analysis is that EU is falling behind in competition. So the digital omnibus is a proposal right now to amend the EU AI Act, GDPR, some other laws, and kind of streamline with respect to cookies. And I'm glad you brought it up, Will. The proposal is to not require consent for cookies like analytics, some first-party cookies, and allowing, if you're familiar with GDPR, maybe allowing a legitimate interest as the legal basis for processing personal information. So yeah, absolutely. I'm glad you brought it up, because really interesting developments are afoot in the EU.
Very interesting. Yeah, one of the things that I heard you mention a few times, Karen, was making sure that um, you have your cookie banners up, your cookie policy, and also explaining what cookies you're using. So I think that's a perfect segue to kind of dig deeper into that. And so for Dominique or any of you all, how do you communicate the differences between necessary cookies or marketing cookies internally to your teams, especially when teams just want all data that's available to make their jobs easier?
Yeah. So this one is actually pretty easy for us. And the best examples that I use are just like, if I'm in a meeting with the business, um, we all have phones, we all have apps, we all see these banners and these cookies every day. So it's just like everyone has the opportunity to say like essential or accept all, decline all, essential cookies, necessary cookies. And so like thankfully, like this is something that the people I work with see every day. So it's really easy to explain. It's like necessary. You need this for the product to absolutely work. Like those, that is like the bare minimum. And then marketing, it's like, that's like the profiling, the targeting, the retargeting, the sharing. Like it's easy for me to explain that. And then, however, the one of the interesting things is as consumers of products, we just only want the necessary pieces of it. However, when an engineer wants to build a new product, they're just like, oh, we do want all of this data. Like, we don't want to have to limit any of it. And I have to constantly remind them to like begin with like the customer in mind. Like, does this make it an enjoyable experience for the consumer if they're constantly getting an email or a text message, God forbid, or a phone call? And so it breaks it down very easy for them. And so the one of the first questions that I will ask when all of these conversations come up is just like, what is the business outcome? Like, what is the minimum that you might need in order for XYZ to work? Then explain the real cost, which is the cost to the customer. Would this be enjoyable? Is this a free customer? Is this a pro customer? Do they want um, I know when I worked at a few other places, like there were conversations about paying so that you don't even see some of these things. I used to work at Facebook. And so it's just like, do we have the necessary DPIAs in place? Like all of these things, especially on the legal side, get factored into whether or not it's not how we explain like a necessary versus a marketing cookie. Um, and then at the end of the day, truthfully, sometimes, especially working in-house, all I can do is recommend and advise. I am not the decision maker, and the business can take on the risk that they want to take. And that is what I have to live with sometimes. It's just like I can only write a risk memo, explain to you the fines, the fees per jurisdiction or whatnot. But at the end of the day, the business is going to be like, we need all this data. We don't need this data. This is what we're going to do. Thank you for advising. And then I go to the next thing.
I could not agree more. For those of you who can't see me, I was sending Dominique little mini claps that I just learned, a very demure clap for millennials and beyond. Because as working in-house, yeah, all we can do is advise and then we push the decision to our business stakeholders to respond appropriately on how we're going to comply and move forward. So let's talk about litigation and enforcement trends. So both Will and Karen, you guys have been alluding to this. There's been an influx of cases starting last year. But how serious are these threats? What are the early trends? And I'm going to combine the question, how are companies successfully defending or dismissing these suits?
I
You,
can.
you want to go first,
It's a
Karen? You want me to
loaded
go?
question, I know.
It's a huge question. So the most of the litigation we're seeing is arising in California
Mhm.
with respect to trap and trace and pen register claims. So where the content of the communication, the pages visited or information that's being uploaded isn't being sent to a third party. California is a little bit unique because the other dual consent states, Florida, Pennsylvania, Illinois, and I'm sure I'm missing some, don't have a private right of action for those types of claims. California does. So I think that's why we're seeing these unique theories popping up. The eavesdropping, the wiretapping prong, so where there's actual content that's being sent, those are claims that we're seeing in these other dual consent states as well. But by far and away, California has the strongest headwinds here. And I don't remember the last count, well over 1,000 claims that have been filed based on some statistics that I saw. So, and they're getting varying degrees of success. Um, some have been dismissed based on personal jurisdiction grounds. So if you're really not targeting or doing business, most of the folks, if you're litigating, the personal jurisdiction thresholds, you may be able to get out of the litigation because you're not subject to jurisdiction of the California courts. That's a defense. We're seeing a lot of motions to dismiss in these cases pretty early on. Um, Another defense is lack of standing. So in order to state a claim, particularly in federal court, but state courts have their own versions of standing as well. You have to suffer an injury as a plaintiff that's concrete and particularized. And what some of the courts in California are saying is that if the cookie is only collecting your IP address, well, everybody kind of expects when you go on a website, you're going to expose your IP address, right? That's just how the internet works. And so that's not a sufficiently concrete or particularized harm. And therefore, there's no standing. We're seeing some cases being dismissed based on that. And it's been a little bit interesting because it varies depending on which district you're in, or which federal court you're in California. The Northern District has been quite critical of these claims. The Central District has been more receptive. I just saw a case in November where the Southern District of California was a case involving Adidas, allowed one of these claims to proceed, I think, in a manner that I don't think the Northern District would have accepted, and finding harm based on the collection of kind of limited information. But at the end of the day, I still think consent is going to be the best defense, clear, knowing, voluntary consent. And I like that defense the best. Because you can argue personal jurisdiction, you can get into a fight over concrete and particularized harm for purposes of standing. But if there's a cookie banner that's clear and knowing, and your privacy policy is clear about what's being collected and who it's getting sent to, I think number one, you may have some of these career plaintiffs that might bypass your website and say, oh, okay, this is not worth pursuing. Or you have a really good basis to say, take a hike and defend your claim as well. Will, what's been your experience?
Yeah. So I mean, well, I'll go a slightly different direction about, is the threat real? I mean, I think the threat is certainly real. How real it is, I think depends sometimes on whose radar you land on. And I think Karen's, exactly right that having that consent there as a starting point is a deterrent to a lot of the more prolific players out there. And when I say prolific, there's a Coalition Insurance is a company that does cyber insurance, and they put out a report every year on kind of annual state of web privacy. And so they put out a report a couple months ago that indicated that 72% of all of the SIPA claims that were reported to it by its clients since July of 2023 have come from 4 law firms. 72% have come from 4 law firms. I know that Karen has dealt with at least 2 of them because we have emailed about, we tend, even though we're different law firms, we tend to sometimes share notes, not about our clients, but about our experiences with some of these prolific players. And so if you can stay off of these prolific players' radars as low-hanging fruit, that is a great sort of first place to start from a defense standpoint. Going a little deeper, and Karen alluded to kind of the standing and early motion dismiss sort of things that you might deal with. I mean, other courts and parties have grappled with issues that are more weedy, like, are the actual contents of what is being transmitted, are they actually contents that are being transmitted? Can the technology actually do what the plaintiffs say it does. And so that's, obviously much further into cases sometimes when those issues come up. But there are a lot of sort of weedier areas, that you could get into. But again, you don't want to ever have to get there. You'd much rather not land on the radar in the first place.
Love that advice. Don't even get there.
Yeah.
Don't be on the radar. So you mentioned consent, Karen. One of the best defense could be consent. This question is for any of you all. What happens when we don't have consent? How should companies handle legacy consent data if prior consent banners were arguably non-compliant? Is there a way to remediate or cure past violations? What were you guys' thoughts?
I'm happy to jump in first. I think, if I don't have consent, I'm going through and I'm looking at other issues. And in general, I'm looking at all of these things when a client comes to me and says, "Hey, I've got this letter or a lawsuit's been filed." I'm getting someone like, Dominique and, some expert who knows the tech. And I'm going with the client. I'm saying, okay, what pixels and cookies do you have? Are they actually collecting what the lawsuit or the letter is saying is being collected? Is the information really being sent? So I've had clients who are like, yeah, we've got a TikTok pixel, but our parameters are set to 0. So, either limited or no information is getting sent back. If the information's not being shared, then you don't have, there's not a claim. So I'm definitely looking at that. Look at the statute of limitations. There's a 1-year statute of limitations under SEPA. So, is there an argument that the putative plaintiff maybe was on the website, more than a year ago? So there's some arguments to be made there as well. Sometimes we argue implied consent. So I'm always running a litigation check on the particular plaintiff. Is this a plaintiff, that's filed, hundreds of these, or has, is kind of a career plaintiff? That my argument there would be this person went to this website with the intent of having their information taken, because that's how they get their payment. And they impliedly consent. They knew there wasn't a cookie banner. They knew that, their information would be taken. So there's definitely other arguments to be made if you don't have the cookie banner and the consent, the express consent. I will say this too, because it's just so important. It's not enough just to have the cookie banner and the good privacy policy that's really clear. You have to make sure that that banner is working, and regular audits of your consent management platform, making sure that the opt-outs are working, that if somebody is saying, nope, don't collect this information on me, or I'm not consenting to the marketing cookies or whatever they are, that is working. I've also had clients who use a particular consent management platform. I think Shopify is one of them that's been a little dicey, and doesn't always work. So you really want to make sure that your consent management platform is really solid, that your cookie banners are working.
Yeah, love that advice. We have to not only have the banners up, but we have to make sure it's working. So that's a perfect segue into how do we operationalize compliance? And this question is for anybody, who in the business should own cookie governance internally? If you're working in-house, do you guys think this should be a privacy, a legal, a marketing function? Or if it's cross-functional, what does that look like? How do you think cross-functional ownership would work in these types of settings?
So I can start first. So First, I think insight should be everyone should have insight. A single team should have ownership, just because too many cooks in the kitchen. What I'm describing is an ideal state. I'm not saying this is how we do it here at HubSpot or past companies. But like one central team should own it. And I say that because it's especially for like these larger organizations, it adds up really quickly. Um, if everyone's emailing like the privacy inbox to your organization or clicking a banner to say opt out, like you have to make sure you keep like updated lists regularly, because consumers or data subjects are very quick to go to a regulator and say, hey, I've been getting targeted messages and I did not consent to this. And so, with even with that though, systems have to talk to each other and teams need to talk to each other because team A over here might manage the system and team L on the other side of the business might be developing a new product that might utilize something that would require an opt-out. But because they're not talking to each other, they don't know that a random customer already opted out of something. And so in places that I've worked, it's always been a team that's adjacent to legal, like their your own like global privacy team or like cookie management team or something very um something run by non-legal but privacy experts. Because the legal people, we're not all tech people, and so we know like the high level kind of like regulatory risks to this, the high level definitions to things, but like on a deeper level of like what happens if someone does click opt out and where is this information stored? How long is it stored? If it's been 5 years, are we still storing it? If someone says delete my data, do we delete their consent as well? Like all of that does need to be tracked in one central team. And then how it does work here at HubSpot is I do have to constantly like if I like I got a ping yesterday from a random engineer saying like, hey, I want to build XYZ. I do a quick review. I have my own checklist. And then I emphasize like, oh, does this system follow opt-outs? And sometimes they might say, oh, what does that mean? Or, oh, I don't know who to go to find this. And then like I can easily direct them to one person, one team and say, talk to these folk. Just make sure that your system is plugged, this new product is plugged into their lists so that we are not sending things to people who don't need to be sent to, or we're not even using data. Because I mean, there's many types of opt-outs. I know we have like machine learning opt-outs, AI opt-outs, cookie opt-outs, remove my data completely. I still want to use your product, but I don't want to use AI. Like there's so many lists and so many opt-outs. It does get difficult to manage, which is why it's best everything is just in one team.
I'll jump in because something Dominique said. I had taken some notes on this question and kind of where it might go. And one thing I had written down, and Dominique hit on this, is that I would rather have as an outside perspective, someone who has to deal with kind of persons who whoever is the person is who I have to deal with. I would much rather have someone who is interested and engaged in this in advance than someone who has it's just been added as part of their job. And so, examples of that would be I have spoken with in-house counsel who have, no knowledge or interest in this area, but have been assigned begrudgingly dealing with this kind of thing. I have talked with folks from, an IT or similar type, role at a company who are much more focused on cybersecurity and hardening systems and who have never really had an interest in the privacy piece of this. That's a hard conversation sometimes because they don't get it. And so, if folks are listening, and they're thinking about kind of, where to position themselves so they can have these roles, um, learning and making it known to your management and leadership that you are interested in this and that you would be a good person to park this with, I think is helpful because it makes it so much easier from an outside perspective when we're trying to. Sometimes I feel like I'm hammering a square peg into a round hole, trying to get somebody to understand why it matters.
And I
Yeah.
love marketing people, but marketing is the last group that I would put in charge of this because they want all that data. So they should be part of the conversation, but they are very hard to communicate with and understand, the risk associated with this.
I'll throw in one more point that I have found interesting. This is a very rare thing that a client has been willing to do this, but again, if you're in a in-house role and you have the ability to sort of think through how do you educate your team, meaning all the persons who are involved in this stuff about these issues. We've all kind of heard probably of tabletop exercises for like data breaches and going through that. I think it's almost now worthwhile, going through the process of if we got a demand letter that said we were using tracking technology, the LinkedIn software development kit on our website, how would we respond? Who would be involved in responding to that? And I think it'll teach a lot about, who needs to be involved. I've had one or two clients that have been willing to sort of go through that and have us kind of help them figure out what that would look like. And so, think of those kinds of exercises beyond just the old traditional data breach, area, as sort of an assessment that you can do.
Really excellent points from all of you all. Dominique, one thing that you said that I want to just put on a t-shirt, legal people are not the tech people. Are not always the tech people, but you can be. So I want to stress this point to the young lawyers. If you want to set yourself apart, please do try to understand the tech. It'll make your job easier when you're voluntold and put on these assignments. Hopefully you won't be the begrudged client that Will was talking about. So just try to embrace it. It's a lot to take in. Karen, you mentioned audits, and I want to make sure that we have a chance to cover that as part of best practices. So this question is for any of you all. When investigations or discovery or demand letters or anything of that sort comes out, what technical evidence do you think becomes critical? Or you can spin it on what are the best practices? What are the best ways we can defend ourselves? Is it the cookie consent logs, just having a list of all the cookies that are on our website? Is it any kind of audits? Is it the vendor contracts? Dominique, you mentioned the privacy impact assessments and the like. What do you guys think are most helpful takeaways for businesses?
I touched on some of them, the kind of the process that I go through in terms of checking, seeing what cookies, pixels, what are they doing?
Mhm.
Who is the information getting sent to? I do definitely want to remind folks that if you get a demand letter, regulatory investigation, litigation, that's a legal claim, a hold notice should go out. So it's important to remember that that this requirement to preserve evidence. So backing up, the website at the time, making sure, because the instinct is, as you pointed out earlier, Sheila, I think, let's go in, we've got this pixel and we really don't need it. We don't use it. Let's just get rid of it. Um, hopefully you're never sued, but if you are and you haven't preserved evidence, then you're facing a potential spoliation claim. I love audits. I love, when the client actually, and again, I see this more with clients who are using third-party consent management platform companies like a OneTrust or something like that, where they're actually tracking and they're able to see, that the banners were working and the opt-outs were working, et cetera. And then I also ask for, was this person who's making the demand or the plaintiff actually on the site? What were they doing on the site? What information was collected? I think all of that is important.
Excellent. We're down to our last 5 minutes, so I just have one final question for each of you. If you just want to spend 30 seconds answering, if you could give in-house counsel one practical recommendation for 2025 cookie compliance, what would it be? One recommendation. Is it have the banners and make sure they work? we are legal and not tech people.
I'll start
Maybe
audit
legal and compliance and in charge, and definitely not marketing. We've had a lot of good tips
marketing.
throughout, so just let us know what is the one takeaway for today.
I would say audit your websites and your emails for trackers. I love Will's idea of actually doing a tabletop exercise. I think that's a great idea.
I- I'll piggyback off that and say that ensure once you know what technologies are being used, ensure that what you say in a privacy policy or your terms about how you use information is consistent with what you find when you do those types of the types of audits.
And I'll say challenge yourself to learn how things work behind the scenes.
Excellent.
That's very important.
Well, thank you all for your time. This has been super helpful for me, and I'm sure to everybody that's joined us online. Um, if you guys, it doesn't look like we had any questions in the chat. It looks like there's a lot of great conversation that was happening. So thank you for everybody that participated in the chat. Thank you all for your time again, for listening in, for participating. This has been a really informative session. I know that I've learned a lot, even working in-house myself, dealing with these issues. So thank you, everybody. This concludes today's session. And if my panelists can please hold on for just a minute. Thank you.